Good evening and welcome. This is a regular meeting of the Planning Board on January 18th, 2024. Pursuant to Section 13 of the Open Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently posting the resolution of regularly scheduled meetings of the Planning Board of Princeton for February 2023 through January 2024. A copy was filed with the Clerk of Princeton on January 17th, 2023. Legal notice on the adoption of said resolution was published in the January 13, 2023 edition of the Princeton Packet. Notice of this meeting also has been posted to the municipal website, princetonnj.gov/calendar. Notice that all regular and special meetings of the Princeton Planning Board will be held electronically via Zoom, was transmitted to the Princeton Packet and the Times, and was filed with the Clerk of Princeton on Tuesday, January 17th, 2023. Please note this meeting is being recorded. During hearings on applications for development, members of the public will have an opportunity to comment and ask questions. Questions may be asked after an applicant's witnesses have testified. Public comment is heard by the board after an applicant's representatives have finished their presentations and have been questioned by planning board members and staff. Those wishing to comment orally should virtually raise your hand by clicking on the reactions or raise hand icon at the bottom of your Zoom screen, or if participating by phone, by pressing *9. Oral comments will be taken in the order in which hands are raised. We ask with respect that members of the public express your views in 3 minutes or less. We will have a countdown clock to help speakers keep track of time. Please note that speakers who exceed 3 minutes will be interrupted. Inappropriate public comment containing obscenity, hate speech, or relating to matters not before the board will be muted. Ms. Phillip, please call the roll.
Before I do that, I want to move over Ms. Penyu. I'm sorry, I believe.
Pallavi Nuka, do you mean?
Yeah, I thought it was her. I'm sorry, it's not.
Yeah, yes, she's here with us now. You moved her over.
Oh, wonderful. Okay. Mr. Boddigheimer?
Here.
Ms. Capizzoli?
Here.
Mr. Cohen? Mr. McGowan?
Here.
Ms. Nuka?
Here.
Mr. O'Donnell?
Here.
Ms. Perlmutter?
Here.
Ms. Sachs?
Here.
Mr. Taylor?
Here.
Ms. Wilson Anderson?
Here.
Mrs. Wilson?
Here.
We have a quorum.
Thank you. Announcements? Excuse me. Justin, are you? There you go.
Yes, thank you, Madam Chair, and good evening, planning board members and members of the public. I just have a quick announcement about the planning board retreat we've been discussing. I sent out some dates that we could potentially have the meeting. February 10th looked like it worked the best for everyone. I'll follow up with more concrete information about date and time, but please continue to send me any topics that you might want us to cover, as well as any dietary restrictions that you have. Last year we had a lunch and I think it was nice, and it was from Taim and it was pretty good too. So please just share, if you have any dietary restrictions.
Great. Thank you for that. Other announcements? Okay, seeing none. I don't think we have any. I'm sure we do not have any subcommittee reports. We also, as was discussed a little bit shortly before the meeting, will not be considering minutes this evening. There's been confusion over minutes on the agenda versus minutes actually circulated. And so we're going to get all of that ironed out and bring minutes back to the board at the next meeting. So moving on to applications and hearings. First up, we have 21 Wiggins LLC. This is an extension of vested rights for site plan approval at 21 Wiggins Street, block 27.02, lots 42, 43, and 44. This is file number 2321-030P. Mr. Mueller, is there anything you need to say about jurisdiction and
Yeah,
notice and whatnot?
they
or-
did provide notice, and it was satisfactory, and the board has jurisdiction.
No, Jerry, this was the extension request and I did not ask them to do a notice for an extension request for 1
Oh.
year.
I thought we did. Okay. Then, if it's just, yeah, it's, the board still has jurisdiction.
Okay. Mr. Lesko, you want to start us off here?
Sure. Thank you, Madam Chair. Jared, do you need to swear me in for this one?
Yeah, if you could raise your right hand, do you swear or affirm the testimony about to give will be the truth?
I do.
So sworn or affirmed.
Thank you. Thanks, Madam Chair. Before you is a request for a 1-year extension of the vesting rights for a major site plan application that this board approved in late 2021 and was memorialized in February 2022. The project's located at 21 Wiggins Street. It's partially the former High Tops building on the corner of Wiggins and North Tulane. The approved project included 19 residential apartments and the adaptive reuse of the former High Tops building as a first floor office utilizing the AH01 overlay. Under the municipal land use law, an approved major site plan receives protection from zoning changes for 2 years from the date of when the findings of fact are adopted. The board has the discretion under that MLUL to provide up to 3 1-year extensions on top of the initial 2-year period. Note that approvals do not expire, as is commonly thought. They provide protection from zoning changes within that period of time. I say that because there have not been any zoning changes applicable to this application. So basically nothing's changed since you've heard it 2 years ago in terms of the zoning for the property. The applicant listed COVID-19 and the downswing in the economy as causes for the project to be delayed in the information that they provided in your packet. The conditions of the board within those findings of fact would still apply for the project, and the master plan goals referenced within those findings still apply. So just to summarize, because there haven't been any zoning changes, because the causes for the project being delayed are fair, and because the goals still apply and are met, it's reasonable, in my opinion, for the board to provide the extension. I know Mr. DeGrazia is here representing the applicant. And Madam Chair, I'm happy to turn it back to you if you'd like to turn it over to him.
Quick question, maybe this is for Jerry. Are new members of the board able to vote on this extension?
Yeah, yes.
Okay. So welcome, Mr. DeGrazia.
Thank you. Good evening, everyone. For the record, my name is Christopher DeGrazia from the law firm of Fegri, Drinker, Biddle, and Reith, here on behalf of the applicant 21 Wiggins LLC. As Mr. Lesko described, this is a pretty simple extension application. The project had a lot of really positive attributes. It included 19 units, affordable housing, green roof, preservation of large trees, EV charging stations, interior bike storage, adaptive reuse of an existing structure. And many of these were before the ordinances that you've put in place for some of these components as well. So it's a great project, and we're in the process of meeting the conditions of approval, satisfying the resolution, which requires a number of different steps from, updating the plans to the deed restriction documents to consolidation of the 2 lots. So we're looking for another year, extending the protection period. Aubrey Haynes, representative of the applicant, is here as well. I don't know if Aubrey wants to add anything, but I'm really just offering him here if there's any particular questions from the board on this.
I have
Okay.
nothing further to add. Thank you.
I'm going to swear you in. Do you swear or affirm that the testimony you've given, any future testimony you might give, will be the truth?
I do.
So sworn or affirmed.
So you swear you have nothing to add. Just kidding.
Yeah. I'm happy to answer them.
Of course, of course. Are there any questions for Mr. Haynes on behalf the applicant or for Mr. DeGrazia? Mr. McGowan?
Just briefly. I know, Mr. Lesko summarized the need for, this application. Can, just for the record, can the applicant state why this is necessary? Why they want this? Doesn't have to be long, but I just think that the applicant should.
We have not been able to secure the funding to build this project as a result of a number of factors, but mostly the economy. The increase in interest rates has made it very difficult to obtain financing. But interest rates are coming down, and actually we have some folks that are we believe have raised their hands. So hopefully we'll get this project underway sometime by the middle of the year.
Is the issue, may I ask, obtaining the financing, or is the issue the cost of financing available?
So before you answer, Mr. Haynes, and I'm not saying these questions are inappropriate, but I do want a little guidance from Mr. Mueller about what considerations the board is allowed to
Fair enough.
to hear and make decisions based on, because I've heard over the years that that finances are an especially tricky area, and that the board really should not be making its decision based purely on financial considerations. So just, give us a little bit of guidance. I mean, Mr. DeGrazia, talked about other factors as well. And so maybe we should be focusing on those. I'm not sure. And I'm sorry to cut you off, Jack. I just don't want to go down a road that we
Right. No, it's well
should
taken.
avoid.
Yeah, I think,
Fair comment.
well, I think the question was appropriate, and it just, if there's a reasonable basis for granting the extension. And that's really it. My board has, I think, a lot of flexibility in the scope of its determination be quite wide.
And I'm happy to answer the question. It's both. It's both the availability and the cost, but mostly it's not on the debt side, it's on the equity side. When interest rates started going up, projects like this became less attractive to investors. So it was difficult to get the project launched with the funding that we had. So we've obviously been able to get through the entitlements process and get the approvals. We've carried the property. We've been paying our property taxes, pretty high property taxes for a vacant property. But we're as anxious to get it underway as anybody, and anxious to deliver those four COA units to the town. We think it'll be a nice project for that end of town, and it'll be good for Princeton. More housing, so that more workforce folks can live there.
Thank you.
Thank you.
Other questions for Mr. Haynes or Mr. DeGrazia? And seeing none, I will open. I take public comment on this, correct? Is this
Yes, open the meeting.
subject to public comment? Okay. I'll open the meeting for public comment. So any members of the public who would like to speak to this issue, address the board, please virtually raise your hand now by clicking on the raise hand icon, or pressing *9 if you're on the phone. I don't think we have anyone who's just on the phone. I'm not seeing any hands go up. We do have 7 attendees in addition to those of us active participants. So public comment going once, going twice. All right, I will close the public comment portion of this hearing and invite board members to offer comments, ask any final questions, deliberate, make a motion. Mr. O'Donnell?
Thank you, Madam Chair. No, I have no further comments and with, unless other members of the board have questions or comments, I'd like to make a motion that we approve the extension.
Moved by Mr. O'Donnell, seconded by Mr. Bodegheimer. Is that right, Nat?
Correct, yes.
Okay, thank you. Call the roll, please, Carrie?
Thank you. Mr. Bodegheimer,
Yes.
Ms. Capizoli,
Yes.
Mr. McGowan,
Yes,
Ms. Nuka,
Yes.
Mr. O'Donnell,
Yes,
Ms. Perlmutter,
Yes.
Ms. Sacks,
Yes.
Mr. Taylor,
Yes.
Mrs. Wilson.
Yes.
Motion carried.
Good.
Thank you. Appreciate
Thank
it.
you very much.
Thank you both. Good luck, Mr. Haynes.
Thank you very much. Appreciate it.
Right.
Take
You're
care.
welcome. Yep,
Thank
you too. Next up, we have Alka Patel Penu. This is a minor subdivision known as the Gulick Settlement, or on a property known as Gulick Settlement. This is at 1082 Princeton Kingstown Road, block 1502, lots 2.01 and 2.03. File number P2323-369MS, and Historic Preservation Commission, or HPC, file number 46HP-2023. Mr. Lesko, you want to?
I just want to advise that
Oh,
we looked at
good.
the notice for this hearing and everything is in order on my end, and Jerry has confirmed that the language was acceptable.
Right, and the board
Okay.
has jurisdiction.
Thank you.
Great, thank you. I really have a mental block about asking that question. And I'll get over it someday. Thank you. Mr. Lesko, please get us started here. Thank you.
Thank you, Madam Chair, and Jerry, I'm ready to be sworn in whenever.
Go raise your right hand. Do you swear or affirm that testimony you're about to give will be the truth?
I do.
So sworn or affirmed.
Thank you. And before we start, Mr. Kennedy, is there anyone else in the attendees you'd like us to bring over?
No, just, I see Kevin Brackel's been moved over. The applicant is here, but I'll be honest, I don't think we need any testimony from them. So we've got everybody.
Got it. Thank you. Let us know if that changes. Thank you, Madam Chair. I'm going to share my screen if that's all right, to orient us to the site. And I see the screen's loading. So Jerry, I'm using the NJ GeoWeb software from the New Jersey Department of Environmental Protection.
Okay.
It's publicly available. The applicant before you is for a minor subdivision, according to the agenda, but really it's a lot line adjustment as no new lots are being created or subdivided out of other lots. The subject parcels are these two where my cursor is currently at. These both front Route 27, which obviously is also known as Princeton Kingston Road. We'll probably use that interchangeably tonight. You'll see the Gulick Preserve is to the north of the property. Kingston is a stone's throw away. Lake Carnegie is across the street past some residential parcels. Both of these parcels are zoned R4, residential 4, in the former township. Lot 2.01 is the larger one at about 11.87 acres. It contains a historic farmstead with dwellings and farm structures on it. You may have noticed even an outhouse was on the subdivision plan that you saw. Lot 2.03 is approximately 0.8 acres. That's this flag shaped lot, kind of in the corner of lot 2.01. Lot 2.03 is currently unimproved with any structures. So Route 27 or Princeton Kingston Road is listed on the proposed future sidewalk network of the sidewalk plan map as adopted in 2017 by this board and carried through in the master plan. Both parcels are located in the Kingston Mill Historic District, and a report from the Historic Preservation Officer was provided yesterday. I believe Ms. Kim is here if you have any questions or to present that. Additionally, we have reports from Mr. Bridger and Mr. Weissman and myself, and comments within those reports that we can hold until after the applicant's presentation. And with that being said, I will turn it back over to you, Madam Chair, unless any members of the board have any questions for me at this time.
Thank you. I'm
Could I-
adjusting so that I can see folks. Mr. Mueller?
Yeah, just one clarification. The applicant has applied for minor subdivision, and in fact, they are subdividing the larger lot to give a small slice of it to the smaller lot to make that smaller lot conforming. So there is a subdivision, and actually a second step will be then a consolidation of the little portion of the large lot that's been subdivided off with the smaller lot. That clear to anybody?
Yeah,
Okay.
yes, thank you. Owen O'Donnell?
Justin, I just have a process question. Did this application go to the site plan committee? I noticed that it is a minor subdivision and we usually send those to the site plan committee first, don't we?
The site plan committee only sees minor site plans. We don't have a subdivision committee at this time, so this didn't go to any other one, but that's a good question.
Any other questions for Justin before we
Yeah.
hear from the applicant? And do we want to swear in other municipal staff before we turn to the applicant? I know at some point this evening, Elizabeth Kim, Derek Bridger, and Dan Weissman may testify. Do you want to wait?
I think it's a good idea doing it now.
Okay, so Dan and Derek and Elizabeth, if you could activate your cameras and let Mr. Mueller swear you in just to get that done. They've all activated their cameras and they've all got their hands raised, Mr. Mueller.
Okay, if you could raise your right hand, I guess they're not coming up on my screen as usual. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
I so sworn or affirmed.
Thank you.
Okay, thank you all.
Thank you.
And none of you has anything to add that's pressing to what Mr. Lesko said before we hear from Mr. Kennedy on behalf of the applicant?
No, ma'am.
Okay. Brian Kennedy, welcome.
Good evening, Madam Chair. All right. My name is Ryan Kennedy from the law firm of Stevens and Lee. Happy New Year, everyone, and members of the board. As Mr. Lesko said, we are technically here for a minor subdivision, but in the form of a lot line adjustment. And when this property as a collective, commonly known as the Gulick property, by Princeton, there was a big chunk preserved, as he showed you. There was a big piece that was kept with the historic home. And then this one buildable lot, interestingly, as you noted, in the shape of a flag, was left when Princeton did the subdivision. The lot in the shape of a flag predates Princeton's flag ordinance and is not compliant fairly with the current requirements. And the requirement in specific is that the flag portion minus the pole, or not including the pole of the flag, be as big as required lot size. So in this case, that's 0.75 acres. We were a hair under that when this was done, and we are here to shift that lot line back a few feet so that the flag part of the flag lot is now compliant, and that would make this a fully compliant lot rather than having a future buyer or homeowner, which is the applicant here, contract purchaser, come in for a variance later. So this will adjust the lines to make it a fully compliant lot in a historic zone. Future development would be subject to historic review, but not having to come back to the zoning board or this board for future relief. We've gone through the memos done by your professionals. We have no issues with really any of the comments at all, and thank them for their help in getting this to this point here. We'll have one witness. I can't say we'll be as quick as your extension, but we don't have a lot to talk about. I'd like, before I bring our exhibits up, if Kevin Brackle could unmute himself, and Mr. Mueller, if you'd like to swear him in, I can have him
Sure.
give his credentials.
If you could raise your right hand. I assume it's raised. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
So sworn or affirmed.
Thank you so much. Kevin, if you could just briefly, I know you've testified before this board many times, give your credentials, and I'm going to have you accepted as an expert here tonight.
My name is Kevin Brockle, Brakel. I'm a principal with Princeton Junction Engineering. I am currently licensed in the state of New Jersey to practice professional engineer. I've done numerous site plans in front of this board and other boards and subdivisions.
Thank you. Madam Chair, if that's acceptable, we'd like to have him accepted as an expert here, as expert engineer.
Yes, we accept your qualifications.
Thank you so much. Also, if it's acceptable, we did provide, I believe, 8 slides in advance, and just in the interest of time, one of them does just say thank you. I would like to share my screen and have that marked as our exhibits this evening, if that's all right.
Sure. Why don't we mark that all as Exhibit A1?
Thank you. All right, Kevin, if we could, let's starting here on slide 2, because this is a portion of Princeton's tax map, and that arrow shows the property that we're talking about.
That is correct. It's more pointed towards the overall lot, lot 2.0, current lot 2.01, but yes, you can see that little flag there.
Next, we've got a kind of regional view, I think very similar to the one that Mr. Lesko showed earlier in orienting the board, but in blue, that is at least one of the 2 lots. I think you could see a little tooth of the flag lot carved out of it, but that you could just briefly orient the board about where this is again.
Well, it's on the let's call it the southwesterly side of Princeton Kingston Road, also known as Route 27. It also has some frontage along the northerly line of Dodge Lane. You could see a little leg that's up the road there. As stated before, it's not far from the intersection of River Road.
Here's I think slide 4 is a bigger blow up here. I guess you can see the arrow points to the flag lot that we're talking about. The blue part that shows the larger of the 2 lots where we're going to borrow a little property from.
That's correct. That's a better picture.
Moving on to slide 5, this is a portion of your subdivision plat that shows the original 2001 Princeton project. Is that right?
That's correct.
And just to orient the board again, the larger lot that we're surrounded by essentially is 2.01.
Lot 2.21. It's lot 2.01. It's 11.87 acres approximately currently. And then you can see the shaded area is the current lot 2.03 at 0.80 acres.
Now, the flag portion, 2.03, does that have any development on it yet?
No, it's a vacant lot with some trees.
And though the 2.01 does have the historic farmstead and outbuildings.
Correct.
So moving on to slide 6. We grapple with the Princeton's new flag rules that came into play after this subdivision was done. Essentially, Kevin, do I have it right that green portion in the back, we are kind of borrowing, or well, we're not giving it back, but we're taking
from, yes.
We're
That's
taking
correct. Taking
13
from
feet from 203, or excuse me, 201 and moving it to 201.
Well, actually from 201 to 203.
Thank you.
13, it's about 13 feet or approximately 4,700 square feet.
And that will make the non-pole portion of the flag the 0.75 acres that it needs to be compliant.
That is correct.
Now, also shown here is the current driveway network. And is your understanding that after we submitted this and that Princeton staff pointed out perhaps a couple of issues with the existing driveway location and has recommended the use of the traditional pole portion of the lot for a new driveway?
That is correct. With the stream, or it's more of a ditch, a drainage ditch, which has riparian buffers to it, 50 foot, pretty much encompasses the whole that current access easement. So it's recommended that we use the pole for, which would be outside the riparian zone, and possibly eliminate any possible DEP permitting needed to develop that part, to develop the new lot 2.03.
And I guess it's our new understanding that under Princeton's new flag lot rules, amongst other things, the driveway actually would have to be in the pole of the flag, or another variance would be needed, and
That,
the applicant is all right with using the pole. Is that?
that's my understanding, yes.
I guess this slide shows that as well. Again, when this property was originally subdivided and preserved, there was a easement created to allow a driveway near where that green arrow is shown through the property, but not through the pole portion. That's the area that has both some wetlands features that would require some permitting for us to do, and would also require a variance. I think the board could grant a variance for us to use the existing driveway, but the applicant is perfectly fine with using the traditional pole portion for a driveway in this case.
That's correct.
Kevin, any other? I think I made a blanket statement that I hope it's correct, that we're good with all of the other comments that Princeton's professionals made. Anything else you want to point out in your mind, or?
No, it seems everything, from the report Stanford, we can comply with all that without any problem. And, I really don't have anything else to add to that.
Thank
There
you.
There were two waivers, Ryan, and they're pointed out in Dan and Derek's memo on the section 2.0. One is fire protection plan. Obviously, there's no improvements being proposed except for the new driveway. And the second is a waiver of the letter from the tax collector stating all taxes and assessments are paid to date. They have not been paid, is my understanding, and maybe somebody on your team could address that.
So two things. And one, we're appreciative of the Princeton staff in allowing this to advance forward. Thing one is that actually through an arrangement between the seller and my client, the purchaser, the taxes were, I believe, brought up to date at the end of last quarter. While I believe the waiver still is appropriate, it's our understanding that they actually are current, and further understand that allowing the subdivision to occur makes this lot sellable by the current owner to my client, and then allow any additional funds needed to pay the back taxes to be available. So the original reason for the waiver was so that could happen, and the funds could be used to pay back taxes or any other obligations they have, perhaps to the municipality. However, I won't be testifying to this, but my understanding is that they have been since paid by the applicant purchaser in order to make sure that things moved smoothly.
Is that just the last quarter taxes? So there could be unpaid taxes going back for a considerable period of time?
It's a little of both. I guess this is all public record, but there was enough back taxes that it would have gone to a lien sale in December, and we made sure that didn't happen. I believe that since we're just still in January, that there actually are no taxes, certainly on this lot, that are unpaid. I can't directly confirm, but we made a significant payment, which I believe covered all of the taxes to avoid the sale in December.
Thank you.
Now, as to the other waiver, we certainly, again, kind of agree with staff that it would be appropriate. We did, though, we'll note, our engineer actually included that information sheet necessary, the flow tests at distance to fire hydrants and whatnot, on the plan. So actually, I think in our mind, we both, the waiver would be appropriate so that information could be provided when the lot was actually developed in the future. And because this is an existing lot, we're not creating a new one. But in this case, it happens to be that we provided, my understanding is all the relevant information from a fire narrative on a sheet of the plans, flow tests, locations of hydrants, et cetera. And that would be carried over, I guess, as a condition when this went to be developed by the new owner.
Thank you.
With that, I believe that's the our testimony in chief, we'd be happy to answer any questions that the board or your other professionals have.
Okay, thank you. So you intend to put the driveway for the driveway for a home that might be built on the newly conforming flag lot in the pole section of the flag, correct?
That
And-
is,
And there are that is unconstrained in terms of wetlands or buffer or anything like that.
That's correct.
Okay, and is the driveway that otherwise would have been used that runs parallel to the intermittent stream or waterway or ditch or whatever, however you want to
yeah.
refer to it, is that used regularly? I'm basically wondering if we might, if not close off, at least have some understanding that, you know, by not using that as access to a new dwelling, you know, it might, you know, if it were used for access to the new dwelling, at least it's using the same existing, presumably impervious cover. And now with the driveway over in the flagpole portion of the newly conforming lot, we're adding more impervious instead of, you know, having a shared use. And I'm just wondering if we might, you know, not be using that other driveway anymore, or whether it's used regularly, you know, and by the applicant. And could you just talk a little bit about that?
I'll start and I'll let Kevin finish. If you could see my cursor, part of this driveway is already, I guess what would become the shared portion is already an
Yes.
existing kind of looping driveway. The upper part where the arrow is an easement that would be new pavement and require some DEP permits. The applicant initially intended, and I think the original idea literally for this site, the plan, because this is where the easements were created when it was originally set up as part of the preservation, was to use this as the driveway. That was our applicant's plan. In talking with staff, we're perfectly comfortable using a totally new driveway. We certainly understand your point, and perhaps granting that variance to allow that as an option might end up in the, you know, possibly, if we can get the DEP permits, save some impervious coverage. We not to say we don't have a horse there. We initially came at it thinking that's what we wanted to do, but we were happy to abide by the staff's recommendations to use the pole.
Yeah, and I'm not arguing that that's a bad idea. I'm just seeing lots of ways for someone who enters off of you know, who enters the property from Princeton Kingston Road, not the flag lot property, but the larger lot 2.01, right? That there are lots of ways to just, you know, turn around and use that driveway for ingress and egress, and that maybe the additional existing impervious cover is not necessary. However, I don't want to suggest that should be a condition. I know that's not what is before the board right now. I'm just looking at it as unnecessary impervious cover that, you know, could go away. So maybe why don't you just think about that a little bit? And I don't want to, you know, take up time while other folks might have question to ask. I see Claudia Wilson Anderson's up, and any other board members who wish to pose questions, please raise your hands. Claudia?
Good afternoon or evening. As I understand it, this flag lot was originally established in 2002 at the time that the land was preserved at 28 acres were sold to Princeton for a park. And the parcel was broken up into 2.01 and 2.03. At that time, I believe, and maybe this is all resolved, so this is a long story about nothing, but I believe $600,000 was set aside for the purpose of renovating the 1697 farmhouse. My understanding was that that money was not spent, and that in 2002 there was a settlement between the Gulicks and the municipality of Princeton. Required the sale of this parcel, this 2.03 parcel. I understand the need for the additional square footage on the parcel to meet the current flag lot requirements. But I believe part of the settlement was, and this is the 2002 settlement, that the money from the sale of this parcel would be set aside for the renovation of the 1697 historic home, and that the deed would be held by the municipality of Princeton until such time that the municipality of Princeton was satisfied that the work was done. How does that impact any of what's going on here, and does it involve the planning commission or anything that we approve now? Or has it already been resolved and I just am a little out of date?
I'll first note that there is there was a subsequent action not involved. So I think your history of things is to my understanding quite correct. My client, the applicant here, is the purchaser of that lot that would have been the funds essentially that you're talking about. There was a subsequent action by the municipality and the current owners that perhaps either Justin or someone else of staff can speak a little bit more to. But ultimately, while I don't believe it is a purview of the board for a condition, what you described is essentially what is going to happen. There is a settlement between the current owner and the municipality. I've been in regular touch with Ed Schmier, who, as the municipal attorney, holds the keys essentially to that process to make sure the funds go to the right place. I'm aware of all these things, and I think you've got it right, but I'd prefer not to be the one to testify to them, I suppose.
Mm-hmm. And if I could jump in, and I see Elizabeth's hands up, and she knows more about all the settlements because of some of the actions that the Historic Commission has really driven with Mr. Schmier. But I guess just first and foremost, my recommendation would be to review this as you would review any subdivision application, against our municipal ordinances and health, safety, and welfare. Particularly, this is a complying application for both parcels. And it, as Mr. Kennedy described, it takes one parcel from non-compliance to compliance. That being said, they are asking for that waiver from the taxes paid, which is not something we see here very often. And it does feed into the reasons for that feed into whether or not this board should grant that waiver. That all being said, I'll turn it over to Ms. Kim. Hopefully I haven't confused people even more. If she would like to discuss more of the more recent actions that have taken place with the property owners.
Thank you. I apologize. I missed part of what Claudia had said. I had to take a phone call. But as far as the latest agreement that was with the current property owner, Gulick, that has been resolved, but at the same time, it is subject for that preservation work to be done pending the funds being re-established for that work with the sale of this lot. So HPC is supportive of this, and they are anxious to try to get that work started because, as you can see, it was in 2002 when this original agreement was. But I do feel that those are two separate ones from this subdivision application at this time.
Thank you, Ms. Kim. Mia Sachs?
Yeah, I can't elaborate too much other than to say that I know this matter has gone on with the taxes for a while. It's come before council a number of times. There was some very bad behavior, and some concerns about the property. And I'm not being oblique. I honestly can't remember all the details other than to say that I am glad to hear, from what I can remember, and it's a while back, there were a number of attorneys like Ed working on it, and it had been resolved. And I think there was interest in the town in doing whatever was needed to stabilize the property and not see further deterioration and neglect and bad behavior and an inability to comply with the original agreement. And so that is the extent, unfortunately, of my memory. But I'm very pleased to hear Elizabeth say that, and this is consistent, that I think we wanted to get things stabilized. So it sounds like that's what this represents, which sounds good to me. So I hope that helps for what it's worth.
Yep. Thank you. Julie Capizzoli?
Yeah, I would just like to weigh in that, it would be great for this sale to proceed, and for a lot of reasons that don't have to do with this application. So it would be, I think it would be, it seems very reasonable to me. And I know the HPC is anxious for this to proceed.
I have a question for maybe Ms. Kim and Ms. Capizzoli. I'm curious about whether, I had raised this question before about one of the driveways, which looked like a lesser use driveway. In a very, very old property like this, is the interior, is the circulation, if you will, of the driveways and access points, are those considered part of the historic design and character of the property, and something that you would not want to mess with? Ms. Kim, you're on mute. I saw
Sorry.
you talking, but
Yes, I would say it is. And one of the cases I would talk about is the recent ice company, where there is the driveway that accessed the ice company that was added to one of the significant features of the property. So the circulation, any site features that might happen, even a bridge or something like that, they are considered part of the historic elements of the.
all right, that's helpful. So never mind what I said before. Are there other, Julie, have you done? Are you finished? I see your hand is still up.
Louise, if I could jump in for a second.
Yes.
When I swore people in earlier, Elizabeth, were you included in that group?
I was.
Yes, it was. Yeah.
Sorry.
Okay. All right. Are there other questions from board members for the applicant or for staff or Mr. Mueller? And if there are no, oh, Mr. Weissman?
Thank you, Madam Chair. Good evening, everybody. I just had one question. We had a comment, and I believe Justin had the comment as well, regarding a pedestrian path easement along the frontage of the property. As I understand it, your applicant is the contrast purchaser of lot 2.03, but we just wanted to confirm that that easement would stretch across both lots 2.01 and 2.03.
Mr. Kennedy?
As I said, we have no objection as the applicant. We passed that along to the owner after our discussion and did not receive any objection back. So,
thank you.
Okay. Any additional comments from Mr. Bridger or any of our other in-house professionals? Okay, seeing none. Oh, excuse me.
Yeah, sorry, I couldn't find the hand raise button, so I did it the old-fashioned way. I had one other comment. The part of the larger parcel that reaches out to Dodds Lane, there's a little kind of narrow part. It's not necessarily material to the application before us here. I did some research on it a few months back for a different purpose, and I've seen it shown multiple different ways. And I can't say for certain right now what the correct way that it should be shown is. But I have a comment that, the staff should work with the applicant throughout this process after this to make sure what is shown on the final plat is the correct way.
I can weigh in on that. I'm looking currently at the original subdivision Nassau Surveying did. And what that was, it looked like it calls out for, it was lot 4, and it was based on a reserve of street use per the file map 1518. So I guess there was a little cutout in there, and this property meets that. That's why it comes up short from, say, the right of way of Dodds. If you, I don't know, do you have that? Would you happen to have the final map for this, the plan of survey and subdivision for Golik Farm?
Are you asking the proposed one?
The right, the one that was originally subdivided this lot to created the 203 lot. If you look on that final plat, in fact, that's how it is. That's how the outbound is shown. Comes up short on Dodds Lane, if you will, from what you see.
And then there's a question if the remainder going to Dodds Lane is its own parcel that the municipality owns, if it's right of way. So those are the types of things that I don't think are obviously germane to this application.
Right.
But in some of the previous approvals I've seen, it seems like, you know, there's been some flexibility, let's say, with how it's shown, and I just don't want to continue that flexibility. It would be great if we could get to the bottom of it.
Okay, well, we can work that out.
Yeah, I'll suggest, so just so I don't forget, we may have discovered through our title company, maybe even an error in one of those courses that might have shifted or appeared to shift everything, you know, towards Dodds Lane or not by about 30 feet. That might be a part of that as well. So I can flag that and show that to you, and perhaps that may help solve the mystery.
That'd be great.
So does what you all just discussed find its way into a resolution without being a condition, or is it just a sidebar conversation that'll be continued? I want to be clear on what the outcome of this little good talk actually is.
If it was amenable to the applicant, I would propose a condition, you know, kind of the open-ended one we have of applicant works with staff, you know, to make sure we're putting the correct thing on there.
I guess if that could be phrased that we would assist. I'm just concerned that if it's something that we can't solve as the purchaser of the flag, that we not delay finalizing this indefinitely. But we would certainly be willing to do everything in our efforts to help solve and correct that mystery.
But just so it's clear to me, the mystery is that little stub going partly but not completely to Dodds?
Yes.
Yeah.
Okay.
Did the owners of the bigger lot, did they consent to this application? It's actually their application, right? I mean, it's their land which is being subdivided.
So the applicant is the Pinu family, the contract purchaser, but the owners of both lots did jointly consent to its filing. So the contract purchaser is applicant with permission and physically executed by the fee owners.
Essentially, my greater concern is that we sign off and memorialize on something with something incorrect on it. Not that I'm doubting the applicant's engineer at all, but just from what I've looked into it in years past, it's a little bit of a complicated issue. So before we accept the proposal as seen tonight, just to verify that's correct.
Verify that it doesn't go all the way to the Dodds Lane right of way.
Whether that's should be shown as a separate parcel, whether it is right of way itself, or I don't think it extends all the way to the right of way. But if you look at our tax map, which is not definitive necessarily, it shows right of way all to the rear of the other parcels that are over there, which conflicts with what we see here.
Okay. Okay, thank you.
So the condition would be that the applicant assists to the extent they can to resolve any remaining questions related to this slice of the of the larger parcel?
I think that would work for us, and I'll also suggest that based on
Will that
the,
work for you, Justin? I'm sorry.
Yeah,
I'm sorry, Mr. Kennedy. I don't mean to
No,
cut
no,
you off.
that works for me. I mean, part of the reason is I don't want to have to send the applicant back to the board if we find out, you know,
Exactly, yes.
something wrong is on here, and we can't sign off on it.
Okay. Mr. Taylor?
Yeah, I just wanted to add my confirmation with Justin's recommendation. I walk by the so-called easement multiple times every week. And until I looked at the map, I didn't know that there was an easement. It's clear from a layman's point of view that there is a lack of clarity and that there will need to be clarity for further action with regard to the property. So I'm simply endorsing Justin's recommendation.
Thank you. Any other questions for the applicant or professionals before we go to public comment?
Yes,
Okay, seeing that. Oh, excuse me, Mr. Muller, go ahead.
I had a question. I wonder, Justin, could you put up the sheet? I think it's the first sheet of G1 or of A1.
Sure, from the applicant subdivision plan.
Yeah. Well, and it's actually from the from A1.
I believe this is A1. This is the proposal. Or
I wanted the sheet that showed the present access and the proposed additional driveway that would be possibly installed.
I guess that would either be the.
That's that one,
exhibits
yeah.
or-
Yeah, that's that. Now, Louise, let me just, is the intention that we're going to permit this extension of the circulation system on the bigger lot to serve the smaller lot?
No,
Okay,
I think that the applicant has agreed with the staff's recommendation that they build a driveway through the flagpole to
Right,
the
I know
flag
that-
portion of the lot, and that the
Yeah.
and my thinking was, well, if you're going to do that, then maybe we can take away some impervious cover
Sure.
on the neighboring property. But then I realized, and it was confirmed by the experts, that the circulation within that
Mhm.
very old historic property is part of the historic.
Yeah.
Yeah, so that was a never mind moment. A
Okay.
Rosanna Dana moment, if you will.
okay. Yeah, it just wasn't entirely clear to me. I knew the whole idea was to have the driveway serving the small lot go up through the basically the pole.
Yeah.
But from the discussion, it wasn't entirely clear to me what we were doing with this proposed 12-foot wide drive. But now that's clear.
That goes away.
Yeah.
Okay. Yep, thank you for that. Oh, helping me to clarify that if it wasn't before.
It probably was, just wasn't clear to me.
All right. So with that, I'll open up the public hearing so that members of the public who might wish to address the board about this application may do so now. If you do wish to speak, you need to raise your hand virtually by clicking on the raise hand icon if you're Zooming. That icon is at the bottom of your screen. I'm not seeing any hands go up. Oh, there's a hand. Dale Mead has raised their hand, and so I would ask anybody else to please, who wishes to speak, to please raise your hand now, and we'll take speakers in the order in which hands are raised. So Carrie, are you bringing over Dale Mead?
I've attempted twice.
Yeah, it's not showing up.
There we go.
Good.
Good evening.
Good evening, Mr. Mead. Mr. Muller will swear you in, and then you can speak your mind.
You can raise your right hand. Do you swear or affirm that testimony you're about to give will be the truth?
I do.
So sworn or affirm, please state your full name and spell your last name.
Dale Mead, M-E-A-D-E, Oakland Street, Princeton, New Jersey.
Thank you.
Thank you. Go right ahead.
I have a minor comment about the property taxes for block 1502, lot 2.03, the larger one. According to the tax collector's records, as of 1/18/24, the property taxes for the last quarter of 23 have not been paid. So you might want to check this tomorrow or as soon as possible, or include it in the resolution that you're going to pass regarding this property. So again, the Princeton tax collector's records indicate that as of today, there is still property tax due on the last quarter. And that includes, it's about $1,200, and that includes the interest as of today.
Thank you, Mr. Mead. I believe there was a condition laid out in one of our staff memos that would require the payment of those taxes before, I can't remember the exact wording. Mr. Kennedy, I see you're nodding your head.
Indeed. I mean, the idea is similar to the funds that are needed for the settlement on the historic preservation part. The whole idea of the waiver and allow this to proceed was to allow the purchase to get to the point so that the purchaser's funds could be used to pay any back taxes that might still be owed. So that condition
Right.
is certainly agreeable to us and our understanding of what would need to happen. Again, we paid a good chunk of it, if not all, apparently, to keep it from going to a lien to get to this point. But that's the condition that we essentially worked out in advance with staff to even allow us to get to this point.
Good. Okay. Thank you very much. That was my only comment.
Thank you very much. Any other members of the public wish to address the board about this application? Not seeing any other hands. So I will close the public comment portion of the hearing. Mr. O'Donnell.
Yes, thank you very much. I don't want to belabor this point, but I just want to make it clear. Are we talking about the delinquent taxes on 2.01 and 2.03 or just on 2.03 that the applicant is prepared to settle?
I'll just say on behalf of the applicant that they all need to be paid, frankly, because there is a portion of both lots, not just the prior flag, but the taxes from the other lot attached to the sliver that, you know, we've showed in green that's being transferred. So we cannot purchase the property unless the taxes are paid. And that is our intention to make sure that they are, because I cannot allow my client to buy a property where the taxes aren't current either. So it would be both.
Okay, thank you very much for that clarification.
Yep, thank you. Other questions from board members? Any last questions, comments? Oh, Paula Vinuka?
Hi, I just wanted to clarify before we move to the vote. So the discussion about the little finger that connects to Dodds Lane, the easement, at this point, it's just a question of whether the maps are correct. Is that what Justin was alluding to? That we need to check that we have the correct map. It's not going to affect the applicant's request to change the lot line, because looking at the map that was just shown, that lot line doesn't reach up to Dodds.
Right.
Okay.
That's correct. Yes.
Okay. Thank you.
Good. Other questions, comments, thoughts? Motions?
I'll make a motion to approve the lot line transfer as
Seconded.
with the two waivers.
Okay, thank you. So that's a motion to approve the minor subdivision that amounts to a lot line adjustment with the conditions listed in the memos and the waivers, or excuse me, is it waivers or variances? that were waivers, I guess, that were requested, and seconded by Mr. Bodegheimer. Nat, did you have anything else that you wanted to?
No,
Okay.
thank you for asking.
Sure. Any final comment? Okay, Ms. Phillip, would you call the roll, please?
Mr. Bodegheimer,
Yes.
Ms. Capizoli,
Yes.
Mr. McGowan,
Yes.
Ms. Nuka,
Yes.
Mr. O'Donnell,
Yes.
Ms. Perlmutter,
Yes.
Ms. Sachs,
Yes.
Mr. Taylor,
Yes.
Mrs. Wilson.
Yes.
Motion carried.
And just to make it clear, one of the conditions I'm going to put in, I'm not sure it's specifically in the memos, is that the sliver has to then be consolidated with the smaller lot.
Yeah.
Otherwise, it's just going to be floating out there as a non-conforming lot itself.
Yes, I certainly understood
Yeah,
that to be the point.
right. Yeah, and that's what I said earlier.
Okay. All right, well, any other business? Mr. O'Donnell?
I feel like I'm David Cohen tonight. If there's no other business, I move to adjourn.
Second.
Thank you both. Moved by Mr. O'Donnell, seconded by Mr. McGowan. All in favor, please say aye.
Aye.
Thanks very much, everybody.
Thank you.
Justin will look for your or Carrie's email about the retreat, and see you all in February. Stay dry and on your feet with all all the snow and ice.
Yeah.
Thanks, Sophie.
Right.
Right.
Good night.
everybody.
At all.
Thank you, everybody.
Thanks.
Thank you.
Have a good night.